Welcome to You on the Law. I'm Steve Cilente, and with us today is Bob Lally, of course, and our guest, Sherry Darcy. We're going to be talking about bankruptcy. Bankruptcy, unfortunately, in more recent times has been a part of our daily language, I think, in the legal business. And so today we had some questions from our viewers regarding bankruptcy. So we invited Sherry here, who does bankruptcy as part of her practice, to hopefully give our viewers some insight about what bankruptcy is about and how it can affect us, you as people as an individual, and certainly those of us in the law who have to deal with it with our various clients. Sherry, first of all, what are the there are a lot of different kinds of bankruptcies, as I've learned. What's the most typical one that you deal with?
Sure, Steve. Thanks for having me. Typically, we're dealing in this day and age with a consumer bankruptcy. Obviously, with the economy and the loss of jobs, a lot of people are finding themselves in situations that they never imagined. So in dealing with consumer bankruptcies, we're primarily dealing with what we might call a Chapter 7. Sometimes we refer to it as a liquidation bankruptcy. And the other type might be a Chapter 13, or what we also might call a reorganization.
Okay, go ahead, Bob.
I want to ask you a question, Sherry, because I do practice litigation and criminal defense, but mostly a lot of litigation. So I probably have as many questions as the viewers. You talked about consumer bankruptcy. Does that differentiate a different kind of bankruptcy?
Well, there's all different types of bankruptcies. You've got people who grow crops, family farmers, so that's a type of bankruptcy, or fishermen. People are out helping feed America. They have kind of their own set of bankruptcies. There's also business bankruptcies, corporate bankruptcies. But most of what we see here in Amador and Calaveras counties are the consumer bankruptcies.
Okay, I think Steve had a question.
I got lots of questions like you, Bob. I don't do bankruptcies, but I deal a lot with family law. And people come in and they're not making it financially together, much less when they are going to go their own separate ways. And it's not unusual for me to tell a client, you need to go talk to a bankruptcy lawyer and consider filing bankruptcy with the person you want a divorce with. And that raises its own issues, whether you do it by yourself or with your soon-to-be former spouse. But I know you talk to a lot of people every day about consumer bankruptcies. And how is that different? If that's one way to put that question.
Different from what?
Like a corporation or a business bankruptcy.
Well, in a consumer bankruptcy, we're typically looking at people who, for whatever reason, may it be divorce, they've suffered a really severe financial blow, and they need some help. They need a fresh start out of it. Oftentimes, with the business, they maybe want to survive and reorganize, and try to keep afloat. So that's one type of issue that we deal with there. They're really looking oftentimes to reorganize, unless they're closing down permanently, and then there's not maybe as much differentiation. But in a consumer bankruptcy, the best case scenario really is a Chapter 7 bankruptcy, if they can qualify and fit into it. Because in a Chapter 7, that's basically the idea of getting a fresh start. It's sort of a short-term process, usually 90 to 120 days once you file in the bankruptcy court, and when you come out of it, you have a fresh start. You're free of all your debts, and you get a chance to start over completely.
Okay. Let's go back to the 13 just for a little bit.
Yep.
Now there, if I understand you correctly, the business essentially says, I need some breathing room. I'm not wanting to disregard and not pay all these bills. They want to continue business so that they're operating essentially with the same suppliers that they have had. They just need to reorient how they're paying things.
Well, not necessarily in a 13. A 13 is also a consumer bankruptcy. What chapter of business files really depends on the nature and how it's held as a business, whether it's a sole proprietorship, whether it's a corporation, and whether it needs to go into a Chapter 11 or a Chapter 13. There's a lot of intricacies there. A Chapter 13 can also allow a consumer to reorganize. And there are situations where a Chapter 13 is what a consumer needs to do and to consider, but those, if I can get people into Chapter 7, that's certainly my advice to go that way. But there are certain situations that a consumer is benefited by a Chapter 13.
Sherry, you mentioned if people could qualify for a Chapter 7. What do you mean by that?
Sure. Many people heard several years back, bankruptcy laws are changing, it's all going to change, you better file now, it's going to be harder to file. And they did change, and they made some qualifications for Chapter 7.
So that was a recent law change, yes?
Yeah, about 4 or 5 years ago, it changed, and in those recent law changes, there's some basic changes that are more administrative in terms of some classes that you have to go to before you can officially file, some classes you have to take after you file before you can get your discharge. But I think probably the most significant one that the consumer sees is this thing called the means test. And so what they're looking at is they're saying, do you have a sufficient income such that you could pay back some of your debt that you owe? And in order to determine that, there's a couple of different ways to do that. One is by looking at the U.S. Census Bureau median income. It's amazing what the U.S. Census Bureau keeps data on. It's not just how many people in your household, but every 3 or 4 months we have a new published median income for each state. So in California, you're looking at, it's usually right around $48,000 for a single person. That's the average median income for a single person household. And if you're below that, you qualify. If you're above that, you may qualify, but we have to look at some other factors that you have going on, and that becomes a lot more complicated. We have to look at your debts. We have to look at, we basically look at it in terms of if you were going into a Chapter 13 plan, we sort of assume that you're going to go into a Chapter 13 reorganization and see if you would qualify for that. And if you don't, then you can still qualify for a 7.
So when you're talking about the means test, whether you're filing as an individual or as a couple, you're going through the same test, but the mean, the average, may be different, correct?
Sure, depending on the size of your household. So for instance, in California, it's usually right around $48,000 for a single person household, $62,000 for a 2-person, and $68,000 for a 3-person. And we can go up from there, adding about $7,500 for each additional person. So the more people in your household, the larger income. And that doesn't mean working people, that's just people. So if you have a single parent with 4 kids, you're a 5-person household.
Bob wants to know if his cat counts.
No, but the dog does.
The dog does. Now, I don't think this is filed in state court. Am I correct about that?
That's correct. Bankruptcy is filed in the federal court, and that is for Calaveras held in Modesto. We're in the Eastern District of California, and
Excuse me, all of Calaveras County?
all of Calaveras County
Interesting.
is in Modesto, yes. Amador County goes to Sacramento, and Calaveras County goes to Modesto.
So the McCollum River's the dividing line?
It is the dividing line, yes.
Interesting.
Yeah.
So after they go through the means test, if they're qualified, then that's when your job really starts, correct?
Yeah, and actually my job really starts when we're evaluating the case to begin with. It's a lot of work to sit down and figure out, are you going to be qualified and what is the best bankruptcy to go through for you? In either case, it's really the same set of paperwork with a little more paperwork in the Chapter 13, but it's the same set of paperwork that the clients have to fill out. Once we decide, yeah, you're going to go a 7, we have to look at a lot of different things. It's not just the means test. So the means test is an important piece. It's the first piece, but the other piece is assets. Certainly we want to come out of a bankruptcy with as many assets as possible. The goal when I'm filing a Chapter 7 for a client is to retain all the assets. That's not always possible, but oftentimes it is. Most of the time it is.
I think in most of the cases that I see that are in conjunction usually with a family law case, they own a home, they've got 1 or 2 cars, may or may not have children. Their credit card debt is usually astronomical.
Yep.
They may have a first and a second on the home, and then television, utilities, and so forth. So you consider all of those, all of the debt, correct?
Sure. When we're looking at a Chapter 7 for the assets, for instance, to see if a Chapter 7 makes sense asset or if we're going to lose too many assets, we're really looking at your basic household furnishings are going to be protected. You know, the couch, the TV. Basically, the trustee is looking at your whole financial picture to say, is there some large assets that you have that I can take and pay back at least some of the creditors something with? So what they're really looking at is your net equity. And unfortunately, in today's housing market, most people don't have equity in their homes. So there's not a lot of equity to protect in things. Maybe they have some equity in their vehicles, maybe they don't. We can protect, and this is really an oversimplification, but what I typically tell people is I can typically protect up to about $25,000 worth of stuff. And that shouldn't be taken rigidly because if people have a small business and they have some tools of the trade, there's extra things to protect there. There's definitely, the way everything breaks down, there's other amounts that we can protect. But the typical run-of-the-mill, if you have less than $25,000 worth of assets, I could typically protect them all.
Retirements, 401ks, 403bs, 457s, and just regular
Yep.
retirement, are they protected?
They are. They are. So that's it. That is something when Congress devised the bankruptcy scheme and when California looked at what assets are going to exempt, they are protecting people's retirements. That's not something that most people can draw from at any rate to pay the creditors because of the tax consequences, and a lot of people can't even access that until they're of retirement age. So they can protect that, and that's over and above the $25,000.
Excuse, Sherry, you mentioned a trustee. What role, who is a trustee and what role do they play? How do they get involved?
Sure. The trustee gets involved once we file a petition. Instantly, a trustee is assigned to the case, whether it's a 7 or a 13. In either case, a trustee is assigned.
And who is a trustee? I mean, where do they find them?
Well, they go to pick them up off the side of the road. No, they actually, there's a trustee's office.
Okay.
The United States government has the Department of Justice. A division of that is a trustee's office.
Okay.
And as a part of that trustee's office, you know, they go through selecting usually experienced bankruptcy attorneys or accountants, and they put them in the position of being the trustee.
Okay.
And the trustee is really the creditor's representative. So if you're a creditor and you're trying to figure out if you have a right in a bankruptcy case, it's really great to get in contact with the trustee because they're the one who is charged with looking at the case, looking at the financial picture of the debtor, and determining whether or not there's assets that can be given to creditor or there's income available. There's an income stream to pull from to give to the creditor.
Is it an adversary relationship between the trustee and the debtor?
It can be, but it shouldn't be. Done well, a bankruptcy should fly fairly smoothly. There is a section of bankruptcy where there's litigation involved, and the trustee may or may not choose to engage the debtor in litigation, but that really shouldn't be a surprise. A good, experienced bankruptcy attorney is going to see that ahead of time and work those things out ahead of time.
Try to negotiate it.
Absolutely. And typically, again, a good, experienced bankruptcy attorney is going to be able to see those issues ahead of time and not let you get into those adversarial type proceedings.
When somebody is considering bankruptcy and they come in to see you or another bankruptcy attorney, I mean, what can they expect? What's the first type of procedure?
Well, first of all, I would hope that they're actually speaking with an attorney. I too often hear from some of the what I might call the bankruptcy mills, because they're popping up. It's a popular area of law right now, that people have gone and spoken with people in the office prospective clients have spoken with office staff, but after 4 or 5 times, they've never even seen the attorney. So first of all, I would hope they're seeing an actual attorney. I think that's the first thing you look for.
Okay.
And then once you're actually seeing an attorney, you should be expecting to give a fairly complete financial inventory, even on the spot, even in the first consultation, because without being able to do that, you really can't advise, at least I as an attorney can't advise a client what direction they need to go, whether they're going to qualify for a 7, whether they need to go down that road, whether they're going to qualify for a 13, or whether something else might help them out.
So before they come see you, they should actually sit down and have a list of assets drawn up.
Yeah, they should. They should have a pretty good idea of what they own and who they owe. Both of those things.
Okay.
Now, in dealing with bankruptcies, now there are assets that are secured and some that are unsecured. I know mortgages, of course, are secured by the home. Most credit card debt is not.
Correct.
And there are other debts. How are they differentiated as far as you're dealing with them? How are they dealt with?
It's a really important distinction, and I think first let me explain to the viewers what the difference is between secured and unsecured, because that's certainly a question I field a lot. What we're looking for in a secured asset, that means that the creditor has the right to take an item back from you if you don't pay the bill. So, for instance, a house mortgage. If you don't pay your mortgage, they're going to eventually foreclose. If you don't pay your car payment, they're going to repossess it. So those are good examples of secured creditors. Unsecured creditors are typically the credit card, where if you don't pay Visa back, they can't come take whatever you bought with it, okay? So when we're looking at a bankruptcy, if an asset is secured 100%, there's really no value to the trustee to try to take that asset because they can't get anything back from it. So a debtor has a decision. Do they want to keep that asset and continue to make the payments, or do they want to get rid of it? Is it too much of a liability? So for instance,
We're talking about like a house or a car at this point.
typically houses and cars. There can be other examples of secured creditors, but typically your house and your car is what you're looking at. Okay?
When we're talking about assets, we're using terms of art, so I want to make sure. Yeah.
So let's say, for an example, that if it wasn't for the other bills, a person could make their house payment on a regular basis, assuming they don't, in this hypothetical, that there's not a second. Are there situations where the advice would be continue to make your house payment, but forget about all this credit card debt and then do the bankruptcy?
Sure, absolutely. Once somebody decides they're going down the bankruptcy road, and going down the Chapter 7 bankruptcy road as opposed to the 13, then my advice to them at that point is to stop paying your bills at that point, your unsecured debts. Continue paying your secured debts, or what we also might call your priority debts, like taxes and stuff like that. So we want to keep paying that house payment if you want to keep it. If you want to keep your car, we need to keep paying that car payment. But a lot of times, unfortunately, in this era of housing crisis, a lot of times my advice is, I have a lot of people come in and say, I just want to keep the house, I can keep the house, I think we can do it. And I'm like, okay, are you on a fixed rate or are you on an adjustable rate? They're like, well, we're on adjustable, but something should happen and it shall be better, we think, in a year when it adjusts. And I'm saying, okay, I understand there's an emotional connection to a home. It's a very difficult thing. We build our homes, we buy our homes with the expectation usually that we're going to live there for a long time. We have emotional connections with them, and only the client can weigh the emotional connection versus the financial. But usually I'm pointing out to them that there's a lot of stress involved in their quality of life. And the stress in trying to make these current house payments when they're so upside down is really impacting the quality of life, probably even more so than their attachment to the home is. So a lot of times people are better off and they rethink it. And if you're $100,000 upside down on a home, which many people are these days, you're really often better off to let that house go back, and in 2 or 3 years, when you can start, after your bankruptcy is clear, 2 or 3 years later, you can start looking for loans again, and you can buy something at market rate, and you're going to be just way better ahead. You can reestablish that.
I know in one of the cases that I looked at, the combined income was like $4,000 a month, but they were going opposite directions. They were getting a divorce. The house payment was $2,500 a month. On a home that had lost over $100,000 of value because there was no down payment when they started. And I had to tell them that from my limited perspective, you're going to need to walk away from the home and go see a bankruptcy lawyer because you're in trouble.
Yeah, I mean, there's just no way, there's only so much money to go around. You know, that's just a reality. And a lot of people are concerned about filing bankruptcy because they think there's a stigma to it. But in this day and age, it is a really, nobody could have predicted, well, I'm sure there were some economists out there that predicted it, but as a rule, nobody predicted it when they were getting into these loans that were going on a few years back. And a lot of people are being stuck with it. And it's an unfortunate reality.
I've always heard that the bankruptcy stays on the record. What record are they talking about?
Your
For
credit,
how
your
long?
credit,
Okay.
your credit record, and it stays on for 10 years.
10
So,
years.
yep, it's
Okay.
certainly there, but usually after about 2 to 3 years of good credit after your bankruptcy, then your major banking institutions will start looking at you again.
Interesting.
Now, in looking at bankruptcies, people that owe taxes, child support, spousal support, and some other things, those are not dischargeable, correct?
That's correct, as a rule. Now, taxes is really complicated, and I've said, you know,
I have a question about that because I see
Well-
all these commercials that say you can get rid of a big tax debt.
well, and that's what I was just answering, is that in reality, the tax code is very complex, and the government is really great about getting you relief from all your creditors except for themselves. Themselves, they kind of hang on to a lot. But there are certain circumstances that you can get rid of your tax debt, but it is much more difficult, and they're really just old taxes. So somebody that filed taxes for 2010 and they owe $10,000, that's going to survive the bankruptcy. Okay? So if there's other reasons to file the bankruptcy, we may still want to do that, but realistically, if they've been making payments on taxes for say for 4 years, for the last 4 years, and they filed on time, and they've been making diligent payments, and they're going through a bankruptcy, that's a tax that we might be able to discharge. That has potential.
Child support?
No, that's going to survive. Yeah, child support's going to survive, family support's going to survive. Yeah,
Spousal support?
spousal support is going to survive.
Legal judgments?
Nope, they're not. They're not going to survive. They're going to go away.
And that's one of the things I know that clients have asked me in the past, that I may be sued, and I know their financial condition, and I'll say, well, if they're going to sue, you just go talk to a bankruptcy lawyer, and chances are, if that judgment that is against you will probably go away.
Yeah, typically it is, unless the debt for some reason is non-dischargeable. But your average client is being sued by Capital One or some other credit card, and those debts are typically going to go away. There are limited exceptions, like there are in the law to everything, but typically they're pretty much going to go away.
There's an interesting question. I think this would be the appropriate time to ask it. Let's say somebody's being sued in a personal injury case. It could be an auto case or something, and they have insurance, and the defendant, for some reason, goes out and files for bankruptcy. What happens at that point? And there's an automatic stay that you can't do anything more, but can the creditor get relief in that situation from what's called the stay, I believe?
Well, it sounds like in your hypothetical, has there been a judgment?
No judgment yet.
Okay, so there is a stay on the proceedings, but it's an unlitigated claim. So, I mean, he could say, I have some claim, unknown amount, to this person, over and above what he's insured. I'm assuming he's insured.
Yes, for the hypothetical, yes.
Yeah, so the insurance is still going to have to pay that amount, but anything over, then he's probably going to be able to get relief from that. But I say probably because it really depends on the circumstances.
Would it make any difference if the plaintiff is actually a child, even though there's a guardian ad litem appointed? Does the bankruptcy court look at it any different, that the child is the one who really is going to get the recovery?
We really don't look at a creditor situation. We look at the defendant, so to speak, or the defendant in the lawsuit and the what we call the debtor in the bankruptcy case. There are some items that you're not going to be able to get relief from, but those are pretty limited. The bankruptcy brush is pretty broad in terms of getting people relief. Now, if there's an intentional tort, an intentional act that the debtor did to somebody and injured somebody intentionally, and there's a judgment, you're probably not going to get relief from that. But if it's just your simple act of negligence, your auto accident, that type of thing, you're probably going to get some relief.
The two of you mentioned a stay. Now, doing family law, I know that if one of the parties files bankruptcy, that anything dealing with the property in the divorce nothing more can happen once a bankruptcy is filed. What does a stay entail?
Sure. Once a bankruptcy is filed, and I mean from the minute that we e-file these days in the bankruptcy court. So from the minute I punch the button and it's uploaded to the bankruptcy court, no creditor can take action to collect and that against the debtor. Okay, and that's called the stay, and it's automatic in every case. So the creditors all get noticed right away, and so the automatic stay prevents that. It also takes jurisdiction of the debtor's estate. So when you're in your family law case, say I filed bankruptcy on behalf of one or both of the parties in your family law case, then your court can no longer make any decisions about that property until the bankruptcy court has done what it's going to do. Then whatever survives, the state court can take back in the family law case and dispose of that amongst the parties. In a creditor case, the state court will have no jurisdiction to do anything.
Okay. We can still get people divorced. That doesn't stop that.
Nope.
But certainly it does put a stay in the family law court on dealing with any of the property issues, or certainly most of the property issues.
And that brings up a really good point. You've mentioned a couple of times the intricacies of the divorce and the bankruptcy. And one of the things people really need to consider is when to file and whether they need to file together. I've seen people really hurt by bad advice from attorneys. They've gone out and they filed, and then they've called up the other side and said, I filed, my attorney says you should file with me. Well, you can't add people into a bankruptcy. So you either file together or you don't. And as angry as you might be with each other in a divorce, a lot of times it's really beneficial to file together. It's kind of you versus the creditors, so to speak, and you really need to keep that. On the other hand, there are situations where maybe the people have too many assets. And that's really, even in this day and age with homes being upside down, it doesn't take a lot. I mean, a couple of nice vehicles and a boat paid off might go over your $25,000. Once you get divorced, you could file individually and each get that $25,000. But as long as you're still married, you only get one exemption. It's called the community still gets that exemption. So it's really important to check with an experienced attorney to see, is it better to file in my situation before I get divorced or after I get divorced?
We've been talking about bankruptcy, and
Yeah.
one of the things that I've heard from my clients is, I can't even afford to file bankruptcy.
Yeah.
All right, what is the typical cost, if there is such a thing, for a consumer family type of bankruptcy?
Sure, bankruptcies can really vary. It varies on the chapter. In a Chapter 13, you're usually looking at $3,000 or upwards of that. In a Chapter 7, you could be looking at anywhere between $1,200 to a couple thousand, depending on that. I think I've seen there are some, what I'll call the mills, that maybe do it for a little bit less, but I think you have to be really careful about, are you actually dealing with an attorney versus a paralegal? And that's a really important distinction to make.
Sherry, just a couple of
Yeah.
quick, maybe you can address these quickly. But I want to reverse the situation, which may be a little consumer-oriented. Say you're the plaintiff in a case and you're going to get a recovery. What happens to that recovery if you file for bankruptcy? My other question, because I think we're getting a little short on time, is there a website or like a government website where people could go to? If you could address those couple of things.
Sure. There's if you're expecting a recovery, that's considered an asset. Okay, that potential recovery is an asset. So if after you file a Chapter 7, you get that recovery, the trustee's entitled to that recovery unless we've declared it in the bankruptcy and we've managed to make it an exempt asset. So it really depends on the amount. So sometimes if somebody comes in to me and says, I'm expecting an inheritance or a settlement, and it's $50,000, then I say, okay, this may not be the right option for you.
Right.
Sherry, it sounds like bankruptcy is a very big area, and if a person really has questions, they ought to be getting a hold of an attorney.
You got it.
Hopefully, we've answered some of our viewers' questions today about bankruptcy, and certainly, if you have questions, call a bankruptcy lawyer. Thank you for joining us on You and the Law.